Hello, everybody. Welcome to the webinar. We will be starting. We have 70 participants, which is lower than the number of people who registered. So I'm wondering if we shouldn't be waiting maybe a minute or two. What does Lydian think?
Or you can already start a little bit with the introduction about ACC or Lydian. And in the meantime, hopefully the other participants will soon join us also.
All right, so welcome everybody and welcome to today's seminar, which is a contractual risk assessments checklist tips and tricks. It's a webinar held by Lydian in cooperation with ACC Europe, Belgium. My name is Geneviève Berube. I'm one of the 3 Belgian co-country representatives for ACC Europe in Belgium. I'm general counsel for Kenvaren, based in Wallonia, Belgium. So we are the European operations of Calgon Carbon Corporation, based in Pittsburgh, part of the Courray Group. Just a few words on ACC for those of you who doesn't know what ACC is. So as you can see on the screen, it stands for Association of Corporate Counsels. ACC is a worldwide organization of in-house counsels. We like to say it's by in-house counsels for in-house counsels. It was founded in the United States in 1982, so that's about 40 years ago. We now have 47,000 members from 10,000 organizations all around the globe in 90 countries. And just in the EU, we were established in 1994. So last year we celebrated the 75th anniversary in November. We are over 3,100 members in Europe in 33 countries. And in Belgium only, we are 155 members. And you have now 3 country representatives, myself, but also Yves Heijmans and Stephanie Kool, both from Chevron Phillips Chemicals. 2 words, the role of ACC is basically to connect its members to people and resources necessary for both your personal and your professional growth. Many resources you can see online. We have templates, several articles. There's a lot of continuous learning in education and seminars like the one we organize here with Lydian. And the highlight, I would say, the traditional, let's say, high point in many European legal councils is the annual conference. We were having in 2020, like May of this year, we were having our annual conference in Brussels. Unfortunately, due to the COVID-19, it's been postponed to next year. You can pencil down April 18th to 20th. Hopefully it will be in person, but you know, we'll have to see how things evolve. This is, for the moment, the dates that we have for the annual conference. It's 2 days of conference with lots of seminars and great opportunities to network. And by the way, membership is not that expensive, dollars, American dollars a year. So I think it's worth giving it a try. Lydian is one of the leading independent law firm in Belgium, and it was founded nearly 20 years ago in 2001, and is now driven by 90 motivated and highly competent lawyers. Its clients are large and medium-sized Belgium and international companies, and Lydian provides to their clients prompt assistance and to-the-point advice, both in domestic and cross-border files. Lydian also frequently handles referral cases from prestigious law firms outside Belgium. Now about our speakers. Today we will have 4 speakers. Each of them will tackle one topic related to today's main topic. First, we will have Annick Motet. Annick is a partner in the commercial and litigation practice, and she also heads the intellectual property team. Then we will have Jo Willems. Jo is the counsels at the commercial and litigation practice. We then will have Iris Hemelaar. Iris is a counsel in the real estate, environment, and regulatory practice. Finally, last but not least, we will have Florence Colpert. Florence is a counsel in the corporate and M&A practice. Now, just before I give the floor to Lydian, a few practical information for today. So normally the GoToWebinar will all put you on mute. You may want to check again. Normally your microphone on your screen should be red. On the left of your screen, depending if you have one or two screens, but you should see the chat function. This will allow you to ask your questions. So today we will take questions in writing. So use the chat function, and then there will be, after each of the 4 sessions, there will be a question and answer period of 5 minutes. And if we don't have the time to answer all the questions, do not worry. Emails will follow with answers to all the questions. On the other side of your screen, you will find a handouts. So you can download the slides already if you wish to. Hopefully you will stay with us during the presentation because not everything are in the slides, but they're practical to take notes. So as I said, for the Q&A, 4 sessions, 4 Q&A sessions, and use the chat function. Last but not least, certificate of attendances. There will be 2 certificates of attendances. One that will be sent automatically to all participants via the GoToWebinar system, and another one for those of you Belgian legal counsel who are members of IBG or IGE in French. You will have your certificate of attendance provided that you also participate to the poll that will pop up on your screen sometimes towards the end. So we want to keep you on board. And those of you who will have answered or participated to the poll session, you will receive your certificate of attendance. So thank you very much. And now I leave the floor to Lydian.
Thank you, Geneviève, for this kind introduction, and welcome to everyone. We have more than 200 participants to this webinar. It's already a big success. And we also have a lot of slides. So I will immediately start with the presentation. The topic that we have chosen is, of course, a hot topic, contractual risk assessment, a checklist that we will provide you with, and tips and tricks. And to introduce a little bit the topic before starting with my part, the commercial agreements, of course, contractual risk assessment is important for all legal counsels and businessmen before entering or reviewing an agreement, that you can identify the potential risks and the opportunities related to an agreement. And on the one hand, identify the best case scenario of an agreement, but on the other hand, and therefore it's the legal part, of course, also the worst case scenario, and also to assess a little bit what are the chances that these scenarios effectively will occur. The potential risk that you will want to take before or when entering an agreement will have to be covered by contractual clauses, and that's why you will remedy these clauses, and it's just these clauses that we will discuss in this webinar. Of course, you can provide or stipulate everything in agreement when it does not go against public order, but the freedom to contract is a little bit also limited because of mandatory law. Mandatory law, which can be the local law of a country, Belgian law we will discuss during this webinar, but can also be, of course, European mandatory legislation, which will apply no matter what. That's also important to address. The risk assessment, we will deal with it from 4 perspectives. The first one that I will deal with or tackle are the commercial agreements. Of course, that's a huge and a broad topic, but we will try to specify it to specific topics which are common to all commercial agreements. Then my colleague Annick, she will deal with the intellectual property agreements. Real estate will be dealt with by Iris, and Florence, she will tackle the corporate agreements. So we have a lot to discuss. I will start with the commercial part, and we did or prepared a little commercial checklist. And of course, we can include in this checklist 15 to 30 items, but we try to just make a selection of the most important topics nowadays, also taking into account COVID-19 and the consequences thereof. So the first check, or if we made the checklist of 5 points, is before check whether there's a mandatory law, because it makes no sense to stipulate or to review an agreement if a mandatory law will apply, which you will also have to take into account no matter what. But then also the second point is to determine the applicable law, because the applicable law will also be very important. You have to start with that before negotiating or drafting an agreement, and to take that into account. Although mostly in all kinds of agreements, it's at the end of the agreement, but you should start with that. Also the competent courts, the jurisdiction is of importance, and also recent developments, arbitration or mediation has become also of utmost importance. You also have to at least consider that. A key point in any agreement is whether you have a valid limitation of liability clause. We also discussed that in detail. And also I know that most of certainly the legal counsels, but also the business people are bored of that. But due to COVID-19, that was a hot topic about force majeure, act of God. People or business or companies could not perform their agreement because of the lockdown or governmental measures. It is also important whether you have nowadays or for the future a tailor-made force majeure or hardship clause. I will also explain what the difference is between those two concepts. And last but not least, it's last in the checklist, provide for correct termination of contracts. We often see that the notice period or damages at the end of the agreement are often forgotten, but most of the disputes concern the termination, wrongful of agreements. To start with the first point, the check mandatory law, of course, it depends on the type of agreement that you're dealing with, and it's a case-by-case approach. So you have to do the reflex whether this agreement could be subject to mandatory law. I refer to a typical Belgian act, the B2B Act, which will enter into force at the latest the 1st of December of this year. And this provides for unlawful terms and unfair market practices and a sort of gray list of clauses which cannot be included in any agreement. So we have to check that. It can also be on a European level in all other countries that you have to check that whether this is not applicable to your agreement. Also, what we have in Belgium, but is similar legislation in France and Spain, is commercial cooperation agreements for which specific pre-contractual information obligations will apply. And if you don't respect them, in Belgium, the sanction is that the agreement is null and void. So it has severe consequences. You also have to take that into account before entering into agreement, whether you complied with all pre-contractual information obligations. A third example is protected agreements, and I refer to commercial agency agreements. It's not typically Belgian concept because it derives from the EU directive, and we all have in Europe similar legislation, which is very protective for agents. What we have in Belgium is very specific, are exclusive distribution agreements, and I will deal with that later on and elaborate a little bit on that during my presentation. But you also have to take into account when you terminate that kind of agreement, you may face substantial damages when terminating this agreement. And the aim for today is more, except for the mandatory law, which is a case-by-case approach, is to focus on more particular clauses or common clauses in commercial contracts. So we will continue with that. And the first important clause, and one of the most important clauses to start with when reviewing an agreement, is the choice of law clause. And then you have to also make an assessment whether there's an agreement effectively between the parties on the law that applies to your agreement. And you have to check that in your contract, of course, stipulated contract, but do not forget, what we often see with clients, it's all the time, is that there's also general terms and conditions, purchase or sales terms and conditions, which also provide for or stipulate that specific law will apply. That's very important to check as well, also whether they can be opposed to the other party. So that's something also to check. Maybe it can be a strategic option not to discuss or not to stipulate in the agreement which law will apply. Then it's of course useful that you know at least which law may apply. And there it's more likely when you look at the European regulation, it's the law of the where the premises are situated of the seller or the provider of the service provider. What people or sometimes also legal counsels often forget is to take into account the Vienna Sales Convention, which applies to the sale of movable goods between professional traders, and which stipulates for important also provisions which are sometimes to the benefit of the sellers, because of the buyer will have to control or verify the goods within 6 months, and otherwise any claim will be barred. So that is also important to check that, and also to exclude it. If you don't want that this convention will apply, then you have to exclude it in your agreement. So that's quite important. The same goes for the forum clause. The competent courts also check whether there's an agreement, also check in your general terms and conditions whether a certain court was agreed with, and that this is also stipulated clearly in the general terms and conditions. The same goes for the absence of such a clause. Then it's mostly where the products are delivered or the services are rendered. This court will have jurisdiction. I also added on the slide the specific rules for Belgium when you're dealing with a party which is not situated in an EU member state. But you will see that on the slide. There should be a link with Belgium at least in order to be able to go to the Belgian courts. Finally, watch out for particular cases, and particular arbitration mediation is not so particular, but people are not often so familiar with arbitration, certainly not with mediation, because we are mostly in Europe with civil law, and it's more in common law that this certainly mediation is a known concept. So you have to check whether you're doing recourse to an institutional arbitration, like in Belgium we have CEPANI, which is an official arbitration institution. ICC you have also, of course, on an international level, but these have their own rules. But be aware, if you don't agree on specific rules, that it may become very difficult to agree on such rules. And when the advantage of arbitration is that you don't have any appeal and it should go quickly, more quickly than court proceedings, it may be very difficult to agree with the other party and also to convince the arbitrators to follow certain rules, and you may have to go to the court in order to rectify things. I also pointed out for commercial agency agreements, and that's European in the European context, that often the law of the country where the agent has the premises will apply. The same goes for the competent courts. An agent in Belgium can start in principal proceedings before the Belgian courts. And the same goes for the typically Belgian concept of the exclusive distribution agreement, where the exclusive distributor has his premises in Belgium. Then he can rely on Belgian law, which is quite protective, and also start proceedings before the Belgian courts. The next point on your checklist should be the limitation of liability. It's one of the most important topics in my view. And the first thing to check is whether your liability clause, you may have it, but whether it's also valid. And that cannot be, for instance, excavation of the agreement, what means that your agreement, you make your agreement useless because you have limited your obligations to zero, that you don't take up any liability. So then it will not be a valid limitation clause. There can also be no limitation for intentional fault or fraud goes against public order. And also the specific Belgian B2B Act also has now also produced a list with forbidden B2B clauses. So you will have to check, certainly in the Belgian context, to check your contract, your agreement, even your general terms and conditions, in order to make sure that it does not still contain any forbidden clauses, because they will be null and void. You also have to check whether you can invoke your liability clause, because you can maybe have such a clause, but you also should be able to invoke it, because otherwise it will be totally useless. And what I mean by that is that you cannot do or perform an abuse of rights and also execute your obligations in good faith. For instance, if there are damages, and we have dealt with such matters where there were damages for more than 2 million euros, and there was a limitation of liability to the amount of the invoice, for instance, and the amount of the invoice was only 2,000 euros. And if you have to present that in court, then experience learns us that then the court is quite reluctant to apply this liability clause. But it could be maybe valid in principle, but in this case or in this matter, it will not be valid. This is also something to be aware of. The liability clause should also be clear. The wording should be clear, because the interpretation will be quite restrictive and not to your advantage, because you have stipulated something to your benefit, and then it will be a restrictive interpretation. The next slides are some points of attention, which I will go maybe through rather quickly. The type of liability, what you can exclude or limit, is the contractual versus tort. Tort is it's a common law concept, but it's a synonym for in Belgian law or European civil law for extra contractual liability. So you have to be very precise. For instance, you can also exclude the liability for pre-contractual liability, information that you've provided for. Also, the author of fault for third parties, you can also exclude your liability for that. So that's also important to take that into account when working with subcontractors or so on. And I also inserted a kind of example clause on the slide. What is really important is the type of damages that you want to exclude. And for instance, in Belgium, indirect damages is not a legal concept. There's no definition in our civil code. So you not only have to address them in your agreement, but you also have to define them and to determine what is considered as indirect damages, what you want to exclude. I've also inserted some examples of indirect damages like loss of revenues, loss of profit, and so on. So it's really recommended to insert a list or to check, at least in your agreement, that there's a list of indirect damages, a definition of that is a non-exhaustive list, and that all other damages can also be part of that definition. The amount of damages, how can you limit it? The amount of damages, you can take a determined amount. That's an amount per occurrence or for a given period, that it will not be more, for instance, an amount of 100,000 euro per occurrence or to all events or per year. That's a possibility. Or you can take a determined amount and limit, for instance, the liability to the amount of your your invoice for services rendered or for the product delivered. I made already a link to the fact that if it's quite low, that may be difficult to invoke that clause, certainly when the damages are quite high. Or you can also link it, and that's recommended, to the insurance policy that you have in place and for which you also pay a premium. So it's very important to do that. And that's why you also have to ensure that there's an exact match between liability and the insurance provision, because the insurance, you take out an insurance in order to cover your contractual risks. So the insurer can also rely on the limitation of liability of the insured. And you have to make sure then in your liability clause that there is exact link or match between the insurance policy and your agreement, because often we see that there's a different definition of indirect damages in the insurance policy and in the commercial agreement. So that's very important in order to align that and to make sure that your insurance covers everything, that there's an exact match with regard to the type of liability, type of damages, amount of damages, and so on. That's really important when reviewing the commercial agreement, to also check the insurance policy in place. The next topic that I already addressed is force majeure and hardship. It has become a hot topic recently in March and April. We have dealt with 20 or 30 files only related to that topic, to the interpretation of force majeure clauses, the consequences thereof. And of course, it's an unaccountable impossibility of performance, and it has three components, like it should be unforeseeable, unavoidable, and impossible, really impossible to perform your obligations, and you don't have any liability. But in practice, we see that most of the clauses in the agreements which were in place before COVID-19 were quite, or there was no clause, or they were quite short and they did not address the consequences. They were not quite clear about it. And then we assisted our clients, and we had two options. We could opt for legal action, but if you want to go to court in March and April, even in summary proceedings, but not sure whether you could even go to court and even obtain a judgment on the short term. And there's also the commercial relation, that you don't want to blow up everything with your commercial partner. That's why in most of the cases, I think that most of the clients were successful in negotiating their agreements, and also renegotiating their agreements with the other partner, also taking into account the consequences of force majeure. Of course, going forward, there will be changes, I think, also for this important clause, because it's everyone knows what may happen now in the future, what can happen again with governmental measures like a total lockdown. And that's why it's still important to check whether there's clause or no clause. If it's no clause, then you should at least be aware of what's stipulated in your civil code about the consequences of force majeure. When there's a clause, please check the wording, because the wording should also be very clear. And it's better to include a non-exhaustive list of situations that are covered. And last but not least, what we have seen also is that sometimes there are some formalities. For instance, you have to notify the force majeure within a certain period of time, 15 days after the force majeure situation occurs. If you don't comply with that, you cannot invoke the force majeure clause. So that's also quite important to check that. No, short. Sorry. Yes. So we have two example clauses that I've inserted in the presentation. The first one is with the endemic and epidemic, where I inserted some examples of how you should maybe structure your force majeure clause right now. And you see also that there was a reference to quarantine measures that was not indicated in the before in the force majeure clauses, and we have now inserted that before. The second example is a tailor-made to COVID-19, where of course clients will also want to take into account the consequences of COVID-19, and they want to expressly include the consequences of COVID-19 also for the future, whereas this is not compatible with the concept of force majeure, and because the condition of unforeseeability is not fulfilled. That's why we have also added that in bold in this clause, which we have provided to clients in order to insert that going forward in their agreements. Difference with hardship, really a little bit quicker maybe, is that it's of course a big difference with force majeure, because there it's not impossible to perform or execute your obligations, but it's from an economic point of view more difficult. And also there is still a liability if you don't comply with hardship. If you don't perform your obligations, you will be liable. With force majeure principle, you're not liable. And the purpose of the hardship clause is that the parties will negotiate again the terms and conditions of their agreement, while with force majeure, you can also terminate, or the agreement will be terminated, or a certain specific obligation if the force majeure will consist or will not end very quickly. Last point, termination of contracts of an indefinite duration. There it's very important to be aware that not only for the protected agreements, as you see on the slide, commercial agency and exclusive distribution agreement, there may be severe consequences, but also for general common commercial agreements of an indefinite duration, you have to take into account a notice period. You have to award a reasonable notice period, whatever that may be, and also damages when terminating an agreement. It's also important to also reflect on that when entering or reviewing an agreement. I've also inserted the consequence of the commercial agency agreement. There, I think maybe a little bit quicker, that take into account that always there's a notice period of at least that can go up to 6 months that you have to award, and there can be a goodwill indemnity for the commercial agent based on mandatory law, and that's for the client that he has acquired, and that may be of use afterwards also for the principal. With the exclusive distributor, that's typically Belgian law, and that only stipulates that he is entitled to a reasonable notice period. So it's not defined even in the law what is the reasonable notice period, and that can go up from 1 month, 2 months to 48 months, and that's a very long period to still work together with the distributor if he already knows that his agreement is terminated. Also the goodwill indemnity, he may be entitled to some goodwill indemnity. It's also important to be aware of that before entering into an agreement. The normal or the common agreements, the general then, there is important, of course, that you provide for contractual provisions, which maybe stipulate also the notice period. And otherwise it will be assessed, and what we often see is that there's no notice period provided for an agreement. Then it will be assessed by the court, and the court will then also apply. We have dealt with many files and matters in court, the court will apply the same principles as for the commercial agency agreement or the exclusive distributors agreement, that it will take into account the length of the cooperation, what was the investment made by the other party in order to determine the notice period or the damage equivalent in damages. And last but not least, the express termination clause. Of course, if you want to terminate your agreement, you have to check whether your agreement does not specify or already contain a clause which allows you to immediately, without going to court, to terminate the agreement. And you have to determine whether you want to provide for an exhaustive list and, for instance, stipulate certain shortcomings, a breach of important obligations. But know that the other party can always contest it and go to court and ask for damages. And in any event, even with an express termination clause, it's really important how it's phrased. But it's very important still, at least on the Belgian law, that the notification is still done. So you have to notify at least the other party, you have to send a notice of default, and then also notify that the agreement is also terminated. That was my part. I see now that we already received some questions, which our marketing assistant was so kind to already address here. So I will have a look at these questions, and I think because we have not so much time, that I will take on 2 questions. The first one is, when should you include an arbitration clause in your agreement? And that's, of course, very a difficult question, because it's mostly you take that on not in an agreement, the usual agreement of general terms and conditions, but you take it on in other more tailor-made agreements. And because of arbitration, if you, for instance, go for 3 arbitrators, it takes a lot of time, and that's not of a lot of cost and money is involved. So it takes it's not very good, and also no appeal. On the other hand, for tailor-made agreements, all your lawyer fees can be reimbursed if you prevail in arbitration. So my recommendation would be not in general terms and conditions, but limit the arbitration to specific tailor-made agreements, and provide in the other, in the general terms and conditions, provide for the competent courts where your company has its premises. But it depends all on the type of the agreement.
Yo, this is Geneviève here.
Yes.
One point of experience on arbitration clause. Sometimes people don't think about it, and they immediately put an arbitration clause without thinking of the costs. Think that the 2 parties having to go for arbitration will have to pay for the salary, or say the costs of the arbitrators. So if you're taking 3, you'll have the full cost of 1 and half the cost of the 3rd one. And you'll have to go to a neutral place. Often it's a meeting room in a hotel. You'll have to pay for that. You'll have to pay for the lunch, pay for internet. So think really carefully if it's a matter that's worth the spent. There are advantages of an arbitration clause. It's more speedy, usually more speedy, and there's confidentiality preserved. So think about it, because sometimes people don't think about those costs.
Yes, thank you, Geneviève. Very useful. Second question, quickly, and then I pass the floor to my colleague Annick. What is the recommended amount to include in your liability clause? That's maybe because I referred to it, to the amount of the invoice. That's what we recently saw in case law, is when the amount of the liability clause was quite low, and then you're confronted with damages which are multiple of that amount, like for instance, in this particular case, it was like 2,000, 3,000 euros, and the damages were 2 to 3 million, that the court was of the opinion that this was an abuse of rights and made the agreement useless, because he did not take up any liability. So there, I think it's best to take into account maybe a higher amount in your general terms and conditions, and a lower amount maybe in specific agreements where you know what will be the amount of damages. Make an assessment not only from a legal point of view, but also from a commercial and technical point of view, and certainly make the combination with indirect damages. exclude the indirect damages already. That will already be a substantial part of most of the important damages, and then take then a quite reasonable amount, higher than the amount if the amount of the invoice relates to a specific product or service, which is quite low. Take then maybe a higher amount, limited for a certain period, and it's just an assessment that every business has to make. We will then pass on to the poll question. The poll question is for us quite interesting, that we can see it's not about the content of the slide, but we can see what is the general feeling about limitation of liability clause. And you can answer this question, and we will take that into account and also inform you about the results there. So the poll is now open, and thank you for your attention.
Bonjour, bonjour. Nous allons passer maintenant donc à la propriété intellectuelle et les questions qui se posent en matière de propriété intellectuelle. C'est sûr que la propriété intellectuelle est un asset important des sociétés, mais en fait, attendez, il y a un petit problème technique. Oh yeah, sorry, I forgot. I was speaking in French, sorry. So intellectual property, it's an important asset company, and of course there is many agreement relating to this, but of course most of the time it's just a few clauses in other contracts, and we don't think about it. It's like in building contract or M&A contract, but in fact there is a lot of issue concerning these. But we will focus on the one we have mostly encounter problem with, and basically it's relating when we obtain the right from a third party interconnection, when there was a R&D, so a research and development project, and also, but not strictly speaking, an IP right. It's a problem of know-how, and the protection of know-how. It's very important nowadays in these business. So the first part is when we obtain a right of a third party, there is basically two types of agreement. Transfer agreement, so that we transfer the ownership of the rights. So basically it's quite simple, but it involves a lot of liability, and I will not go back to this issue because they are quite similar regarding any type of contract. But also you can transfer your, not strictly speaking the IP rights, but the right to use the IP right, and it's through license agreement. And one of the main issue we encounter first is to see whether it's a transfer agreement, so transfer of ownership, or transfer of the right or license to the right to use the contract. And then you have to, it's the first thing that you have to double check what exactly is transfer or license, because then it has different consequences, and which affect, of course, the rights in general. So it's basically, and often this problem raised through software agreement, maintenance agreement, and then regarding software, where it's not very clear whether we have the right, the ownership, or whether we just have the right to use. So it's the first clarity and checks that you have to make. After, you have to, in the license agreement, the basic checklist, I would say, it's on the slide, but it's mainly whether you have exclusive right or not, grant exclusive right or not, whether the owner of the rights can still use the right or not, whether he can transfer it or to somebody else. Main issue also, it's improvement of the IP rights. So like if you have a license of the software, what matter if you develop and you have another specific software that it's also can be protected? What is it? Are you the owner, or whether the owner still remain with the one who granted the right to you? So it's very tricky part, and then you have to make sure that in your agreement this is very clearly mentioned. The issue also to be tackled in the agreement is to what happens if there was a claim by a third party or against a third party, who is doing what, because then it may raise another problem, another issue. Of course, a tricky issue is also the way you are going to calculate the remuneration, compensation for the right that you are granting, or whether you are obtaining them, whether there is quota, whether there is target, whether how you're going to double check whether you trust your contractual partner, whether you're going to put in place some audit, who is going to pay for these audits, so that it's really, that list is a really main important checklist that you have to double check. And of course, there is also an issue with regard to pricing, because of course you want to have a revenue out of the license, or you want to minimize this, whether you will have suggested price, and there you have to be careful about all the competition aspect of your contract. Of course, we cannot go through all these detailed question and checklist, but we have selected two main issues where we have faced the most of our problem, or your problem, I would say, that we have to solve, is really the issue with regard to copyright and the registration of these rights that you are transfer or license. Copyrights, in fact, is subject to some harmonization directive, but not a global like you have in trademark rights or design rights. And of course, the EU Commission is working on it, but still there is no global harmonization. And of course, as a Belgian lawyer, I will focus on the Belgium aspect of the case, but I will try to make some point where I can see some difference with some main country. And with regard to transfer of copyright, basically it's we are in a country like in France, very focused on the protection of the author. So you need to have a written agreement, otherwise the rights are in any case for the owner. It's protection of the creator, so the philosophy behind that. So you have to keep in mind that. Also, it's restrictive interpretation. So if it's not provided in an agreement, it's not implicit. And there is a prohibition of general terms. So if you provide for the transfer of right regarding the reproduction of a work, the modification of a work, the right to distribute, it does not imply necessarily the translation. So for instance, if it's a written work in French or in English, then it does not imply that you have the right in another language. So you have to make sure that it's provided in your agreement. And also you have to provide a specific compensation for each of the form of exploitation. So it's quite important to provide that in very detail in your agreement, and specific also type of work. But of course, and there is also some specific in the audiovisual work, you have also specific approach. And for instance, it's very different, like in the Anglo-Saxon UK country, you can have usually the clause just provide, okay, I transfer here all the IP rights to the other party, or I license all the IP rights, but it won't work in Belgium or like in France. And also these relate to the economic rights, so the right of exploitation. But then you have to take into consideration the difference between the European country regarding the moral rights. So in Anglo-Saxon country, or like in Germany and in the Netherlands, you can transfer your moral rights. But in country like France, these rights are not transferable. So it's inalienable character. So that the right of disclosure, so the fact that you decide whether you disclose or not your work, whether you right of integrity to modify the work, and the right of paternity. And this is quite important in real estate, for instance, business. When you work with some architect, so if you really need to have this possibility to modify, and so that what we do in Belgium, in fact, Belgium is it's a compromise country, typically Belgium approach, and so that in fact you could waive some specific modality of your rights, so that you cannot waive any of your moral rights globally, but you could say that, okay, I accept that, for instance, my name does not appear on the work. So it's specific, it's limited, and it's okay, provided that you always have the right to intervene if there is a problem with your reputation or your honor. So this is basically the rules, and that you have to be very careful about it when you contract with people in our country or in France, for instance. Then the other main issue that we have faced in transaction is that when we notice that we forgot, or the client forgot to register the rights or the licensee, because then in fact there was no global harmonization with regard to this aspect. And then in some country like Germany, as of the signature of the contract, if you have a license agreement, you can go and have your rights towards third party. But in country like Belgium or Spain, you need to have your rights registered to be able to license agreement, to be able to act against another party or third party. So it's very important to have this registration made at the time of the signing of the contract, because then if forgot in the course of the business, then if, for instance, there was a merger and acquisition after a sell agreement of the company, then of course it's good business for us. But, we have to regulate everything, and sometimes the party who has previously owned the agreement is disappear, it's in reorganization, it's bankrupt, so that we have issue in recreating and making the registry going through. And then also, of course, it's related to patent, trademark, and copyright in most of the country are not registered here in Europe, but you can find some way to have, or like for the software, you can make it like e-depot, but then it's more like not for the opposability of third party, but it's more like an evidence of the reality or the date of the rights. So that the other issue we have encountered in research and development, that the people forget again that the rights usually stand in the one of the creator, and specifically there I put on the slide the difference, so that in fact the creator is protected, and in the absence of any clause providing for such, it will be, the right will be owned by the employee or and not by the employer. Like in copyright and patent, it's very important to have these provided in the contract itself. So I just go, yeah, because if you are not providing that in the contract, that means the employee still own the rights. And then when you want to transfer your company or some asset of your company, then you have to put in place some contract. And of course, it's very complicated to have these measures put in place. But then once you have expressly provided in an agreement, then you don't have to go into the details of exploitation rights and remuneration for each of the exploitation rights, economic rights, and then, but providing that these rights have been developed in the course of the business of your entity and also in the scope and during the execution of the contract. And regarding the patents, in fact, in Belgium, there is no specific provision, and it's based on case law, and usually it's the employee who owns the right if there is no transfer specific clause. And of course, there is always a discussion whether the invention fall within the contract of the within the task of the employee or not. So another, of course, this is an aspect with the employee, but also regarding the third party. So if you order something, and specifically here, hopefully, there is some law for database and design. You could see that, in fact, it's the client and you are the owner when you order such a work. But you have to keep in mind that like for software, if you buy a software, you have an invoice, and people sometimes think, yeah, but I bought this. I look at my invoice. I have paid for it, and I'm the one who can exploit. And but in fact, no. If it's not specifically provided that there is a transfer or a license, then in fact the developer is still on the rights. And then, of course, when you want to change developer or you want to change software maintenance, then you are faced with an issue if you are just based on your invoice. So you have to be specific and provide in the contract really what is transfer, for what price, and of course it has to fall into your activity. And then with regard to transfer of patent, then it's if you order it the same basic like when you have employee. Then really relating to research and development, and the main issue that we have also encountered so far, it's the protection of know-how and trade secret. I mean, there is an harmonization at the EU level now in place. So it's more, the concept are more trans-border, it's easier, but still, despite the fact that there is an harmonization, it's really important to provide specific laws with regard to some aspect of these trade secret and know-how, and specifically to define them and to make a list of what is to be considered as secret. The extension, to provide for extension, to make sure that the staff and the subcontractor are also bound by these obligation, and also the problem of at the end of the agreement, what happened? Do you have to give back? I mean, I think that I see a lot of contract providing for restitution. Restitution, it can be helpful if it's concrete, it's a document or it's a project or it's concrete, but usually deletion is sufficient and you don't really need to restitute the terms. Another issue to have to check and really have a reflection about it, it's about what happened at the end of the relationship. Do we provide for a term or not? And I know that a lot of in-house counsel provide for a clause that it lasts for 5 years after the termination of the contract. But what about if it's still valuable? So me personally, I think that if you have a secret and it's still valuable after 5 years, you have to provide a clause where you don't put a limit, and it's as long as it's secret, and you had put some measure to keep it secret, you are bound, and it's longer than the 5 years. So if you want to put a deadline, you can put 10 years, you can put 20 years, but look, like the Coca-Cola recipe, it's forever, so that it can be as long as it's secret and you have taken some measure. It's quite important. But I know that in some enterprise, they want to have, okay, we know that after 10 years, it's no longer really valuable, and then we want to be free, and also to be easier to manage the company, and then you don't have to keep contract longer than 10 years, I would say, so that it's also quite an exercise. Of course, to ensure the protection of your rights, what you do also often is to provide for non-competition clause. Then you have to be very specific, because what we see that people often just provide in the agreement a very broad aspect, a very broad clause, and in fact it's cover all worldwide and all the activity, and even where you are not in business, and then it's null. So it's better to restrict it, to make sure that from a competition point of view your clause is valid. The good things, for instance, in Belgium, is that now it was totally, absolutely null. But according to the most recent case law, the judge will be able to keep it valid as to the extent as possible. But then you have to, it's really advisable to provide in your contract that it doesn't lead to have separate limitation of the annulment, and also eventually to provide for an indemnity clause too. But then I refer to the presentation of my colleague in that kind. So, and also you have to be careful, because that applies to third-party contractor, but with employee there is very strict other rule applying, and you have to provide an indemnity in case you want to make. So you have to really balance whether you need a non-compete clause after the termination of the agreement, surely during the terms, but after, do you really need a clause providing for the non-competition clause. So I don't know whether there is any question. I see. Yeah, I did not talk about, so there was what about artificial intelligence? I did not talk about it because in fact, it's very still in the movements, and there was no really strict line, and we apply the basic rule of copyright, and artificial intelligence is still on the move. Some countries consider that it's a new right and a new owner, but in most of the European countries, we consider that it's still the basic rule which applies, and so you will go behind the scene, and it will still be the physical person behind it who will own the rights. And for that, if you are interested, I recommend to read the report made with the IPPI relating to the matter, and suggestion on the way forward, so that you have really a good analysis. And I can send you the link to the IPPI website, where you will find all the reports at the international level. But the question is really still very open. So that if there is no other question, Geneviève is fine. Then to keep also strict, I see the time, we will go to the poll question, and I will give the floor to my colleague after. So we will have a few minutes to, but it's very simple question regarding the poll. Asian, you can put it in, and so that it's just to have an idea of what is the most valuable right within your organization, so that we can have a little bit a focus. But obviously, I guess that I'm interesting to see whether copyright is very important within your organization, because it's the most discussed issue. And so that after the poll, Iris will address the issue, tips and tricks regarding to real estate business. See you later. Bye-bye.
Well, good afternoon, everyone. My name is Iris Hemelaar. I am a counsel within the real estate, environment and regulatory department within Lydian, and it will be my pleasure to guide you through some important topics regarding to the drafting of real estate related contracts. Time frame is quite limited, so unfortunately my presentation will be quite limited as well. I will limit my presentation to only 3 topics. Those are the most important real estate related topics nonetheless. We'll start with the property purchase agreement, then lease agreement, and then finally I will shortly discuss the contractor agreement. When you're being asked to draft a property purchase agreement, the first thing we would like you to do, which is very important in fact, is to first check the location of the property in order to apply the applicable regional legislation. Since in Belgium we have different legislations in place depending on the region where the property is located. And there are some quite important topics there. For example, soil certificate, town planning, some tax matters. These matters might differ depending on the region. Yeah, on the next slide we have put some key issues. I will not go into every key issue because time is limited. What I would just like to point out is that it is quite standard for the parties to first enter into a preliminary sales agreement, but please do not forget to confirm the preliminary sales agreement by a notarial deed within a period of 4 months. This period of 4 months, it starts to run as from either the signing of the preliminary sales agreement, either when the conditions precedent have been agreed, as from the fulfillment of all the conditions precedent. Please also note that some mandatory documents or information must be available upon signing of the preliminary sales agreement. So after you have checked the location of the property, please take into account that several documents and information have to be present sometimes at the moment of signing of the preliminary sales agreement. And do also consider that the delivery of this information in Belgium, unfortunately, might take some time. So do count a couple of weeks before you will have the information in hand. Defects is a very important topic when drafting a property purchase agreement. In general, we make a distinction between visible and hidden defects. For visible defects, it's quite simple. In principle, there is no guarantee to be provided by the seller, which is normal. The buyer has a chance to inspect the property and to detect any defects in the property itself. On the contrary, for hidden defects, it is obliged for the seller to guarantee the absence of hidden defects to the buyer. However, it is possible to derogate in mutual understanding in the purchase agreement. But please do note, this is an exception to the rule, that for a professional seller, it will not be possible to stipulate such derogation. And also, if the case the seller was aware of the hidden defect, it will not be possible to derogate from this obligation to render a guarantee. Okay. Yeah, that was everything. No, I skipped. Yeah, I skipped one issue. This is the last issue with respect to the property purchase agreement, which is the conditions precedent. I believe there won't be any need for me to explain to the audience what a condition precedent is. I would just like to point out that these clauses should be drafted quite carefully. So drafting carefully, provide for an information clause between the parties, provide for a time frame in which the conditions precedent have to be fulfilled,
Maybe you can provide for an option for the possibility for the parties to extend the term in which the conditions precedent have to be fulfilled, and also provide for a long stop date, so a final date by which the conditions precedent have to be fulfilled. And please also consider what will happen in case the conditions precedent have not been fulfilled. Will there be a reimbursement of costs made by one of the parties or both parties? We do advise you to take that into account. Then to our next agreement, which is the lease agreement. I will be quite short on this issue. I'm repeating myself because for lease agreement, in fact, the first thing to do is identical as when you're being requested to draft a property purchase agreement. First, check the location of the property. Also for leases, the legislation might be different depending on the region where the property is located. Yeah, of course, we have different kinds of lease agreement: commercial leases, residential leases, common lease agreements, such as renting out of office space or warehouse space. And on the next slide, we have enumerated some key issues. I will pick some of the key issues out for you, since I do not have the time to go into detail in each of these key issues. First key issue is the duration of the lease agreement and the termination possibility. I will be quite short on this. You can find all some information on the slide. I would like to point out to you that you should consider that there the legislation with respect to commercial lease and residential lease is quite protective for the tenant. So as for duration and termination possibilities for the lessor, in case of a commercial lease and a residential lease, there are certain limitations, especially for the lessor. On the contrary, when you have a common lease agreement, for instance, for office space, the parties are quite free to determine the duration as well as the termination and termination possibilities. The inventory upon entry, I will skip this subject and I will refer to my slides. Repairs and maintenance, also a very important topic. Parties are free. There are several options open, so the parties can decide which regime they will apply in the lease agreement at hand. Normally, the gross repairs and the repairs due to age or force majeure are at the expense of the lessor, and then the other repairs, the rental repairs and the minor repairs, are at the expense of the tenant. But please note that the parties are free to derogate from the legal provisions in this respect, and we believe it is quite important to clearly define the rights and obligations in the lease agreement itself. VAT, a final topic or points of attention with respect to the lease agreement. This is quite recent. I would just like to point out to you that as from the 1st of January 2019, it is possible for the parties to apply VAT to a lease agreement. Of course, certain conditions will have to be fulfilled, and also please note that the landlord and the tenant will jointly have to exercise this option. Okay, let's pass on to our last contract, which is the contractor agreement. Again, some key issues can be found on the slide. The first point of attention is the description of the contract documents. When parties are negotiating a contractor agreement, they will not be negotiating the contract agreement itself, but they will also be negotiating the annexes to the contractor agreement. Those annexes, they're quite technical. They can be plans, drawings, price list, a bill of quantities, etc. So we believe that it's quite important to define the contract documents and also to determine a precedence between those documents in order to avoid any discussions afterwards between the parties. Another important point of discussion or point of attention is the qualification of the obligations of the contractor. Generally, a distinction should be made between obligation of result and a best efforts obligation.
Please note that the qualification of these obligations is quite important. So when we are dealing with an obligation of results and the result has not been achieved, it will be up to the contractor to prove that the absence of the result was due to an external cause. On the contrary, when we're dealing with a best efforts obligation, it will be up to the client to prove that the contractor did not act as a normal, prudent, and a diligent person placed in the same circumstances. So well, sometimes there are a lot of discussions about the qualification of the obligations of the contractor. Execution period, another very important topic, of course, for a construction project. The deadline for finalization will be mentioned, of course, in the contractor agreement. It can be expressed in calendar days or in working days. For large construction projects, we generally see that milestones are being defined, and they will be annexed to the contract. And of course, we're talking about penalties in case of late performance. What you should think about is, okay, will there be a prior notice of default required in order to start run the penalties for late performance, or will they be due by operation of law? And then also the penalties, the amount of the penalties, will it be a lump sum compensation? For example, X euro per calendar day, per working day. Sometimes the amount of the penalties for late performance can be kept. They can be kept to a certain total amount. They can be kept to a certain percentage of the contract price. Or will the client go for a full compensation in case of late performance of the works? Another important topic is the acceptance of the work. I would just like to point out to you that a distinction should be made between the provisional acceptance and the final acceptance of the work, and that the provisional acceptance of the work merely establishes that works are being completed. In principle, and of course, again, it's possible for the parties to derogate from this principle, which they generally do, by the way. The approval of the works occurs at the moment of the final acceptance of the work. And then between the provisional acceptance and the final acceptance, there will be a certain period of time, for example, 1 year. And in this period, the contractor will have to remedy to all the defects which might occur. But it is very important to clearly determine the meaning and the effects of the provisional as well as the final acceptance in the contractor agreement. Guarantee period. In Belgium, a contractor is obliged to a 10-year liability as well as a liability for hidden defects. In principle, this guarantee period starts to run as from the final acceptance, but we do admit that it is possible to derogate from this article and from this principle. And generally, the parties agree that the liability or the 10-year guarantee and the liability for hidden defects starts to run as from the provisional acceptance. Then another very important topic, we do advise you to mention a clause in the contractor agreement. It's a good change of procedure clause. Changes will occur anyway for smaller construction projects, for large construction projects. Changes will have an important impact, or can have an important impact on both timing and price. So please mention a good change of procedure contract clause in the contract, just to avoid discussions afterwards. I refer to the slide. On the slides, the following slides, you will find 2 suggestions of clauses with respect to the changes procedure. Then let's pass on to our next subject, which is the termination of the contractor agreement. I will be quite short on this one. Just make sure that in the contractor agreement, you make a clear distinction between the termination in the absence of a contractor's default and the dissolution of the contract due to the non-performance or a contractor's default. With respect to the termination in the absence of a fault by the contractor, please note that under Belgian law, the client always is entitled to unilaterally terminate the contract at any given time and without any motivation. There are two conditions will have to be fulfilled unless agreed otherwise. The first condition is that the contractor will have to be compensated for the executed part of the works, including the delivered materials. And then the second condition is that the contractor should be compensated for the loss of profit on the non-executed part of the work. As said, it is always possible to derogate from this principle. Then in case of a contractor's breach, dissolution due to a non-performance by the contractor, as Jo mentioned at the beginning of the webinar, for a dissolution of a contract and also a contractor agreement, you will need to go to court. So if you want to replace your contractor, you will have to go to court and ask the court for a replacement. But it is possible, once again, to derogate from this principle and to foresee a replacement clause in the contractor agreement. I refer to my slides. We have added some good clauses with respect to termination of the contract. Then force majeure, I will skip this subject. I believe Jo has already enlightened you with respect to force majeure and hardship. And last but not least, the dispute settlement. For dispute settlement, parties are free to choose. There are several options. Parties can go to court, parties can go for an arbitration. What we generally advise our clients is to mention obligation in the contract for prior consultations between the parties. For example, a management consult, parties should first try to solve the discussion between them before going to court or to an arbitration. Then for large construction projects, also for smaller construction projects, for technical disputes, it might be useful to foresee a procedure or an article regarding the binding expert's decision. And then last but not least, do be aware of the continuity of the works. So what we would advise you is to foresee a clause in the contractor agreement which obliges the contractor not to suspend the works, but to continue to work in case of dispute. Yeah, I refer again to my slides. We have some nice clauses with respect to our last subject, the dispute settlement. Okay, I don't know if there are any questions with respect to my part of the... okay. One question just popped in. The question is concerning the penalty for late performance by the contractor, which caps are generally applicable? Well, all depends, of course, from the size of the construction project and the amount, of course, of the construction project. But generally, we see caps between 5% of the contract price up to 10% of the contract price. So I hope this answers your question. Okay, as always, we have a nice poll organized. The poll indicates at hand for my part is a statement, and we invite you to answer this statement as true or false. So the poll question is, the client is entitled to terminate a contractor agreement at any time without motive. So it's up to you to decide if this statement is true or false. So I thank you very much for your attention. I hope it was useful. And I will now give the floor to my colleague, Florence, who will enlighten you with respect to corporate aspects.
All right. Good afternoon, everyone. My name is Florence, and I will be touching upon corporate contracts today, and in particular, acquisition agreements. So acquisition agreements are quite complex contracts and quite broad as well. So I chose to focus on three elements, which I believe have a particularly importance and relevance in the current context. And those are earn-out clauses, material adverse change clauses, and the use of warranty and indemnity insurance in the framework of acquisition agreements and to cover the seller's liability. Let's start with earn-out clauses. So as a reminder, an earn-out is a mechanism whereby a part of the purchase price is deferred and will be calculated based on the future performance of the acquired business over a specified period of time. So You see here the two essential elements, which is the future performance of the company on the one hand, and how that will determine the earnout, and on the other hand, the period over which the earnout will be calculated. So to keep in mind, with respect to the future performance and how the earnout will be calculated, financial thresholds are of course often used, but for an early development stage company, you can also take non-financial milestones, such as, for example, the obtention of regulatory approval. With respect to the time periods, what is important to keep in mind is that a short time period could create a distortion in the sense that it could be impacted by some punctual events. You could have a very good year in the business or a very bad year, so it could go both ways. And if the seller is still involved in the business, which is often the case, the seller sells but then remains involved in the management of the business, then he may be tempted to take some decisions that are short-sighted and that will advantage him in his earnout, but may not be in the long-term interest of the company. So that's definitely something to keep in mind when determining the earnout period. Earnouts are very often subject to disputes between the parties. So usually the seller will want to review what the buyer has made of the calculation of the earnouts, and that can lead to disputes. So often the clause will provide for an expert, which will be appointed by the parties and who will settle the dispute between the parties so that they don't have to go through arbitration or litigation, and that the dispute can be settled quickly. Also because it's often of a financial nature, which requires then that an expert is appointed, and often it's an accountant. The earnout clause will also, from the seller's perspective, need to address the fact that the seller is no longer in control of the business, but his earnout depends on it. So there is a distortion there as well, because the buyer, as the new owner of the business, could influence the earnout targets through operational or accounting changes. So the clause will usually include a protection mechanism for the seller, such as a restrictive covenants on the purchaser. So providing, for example, that the purchaser has to run the business in the ordinary course consistent with past practices. The clause can also give information and audit rights to the seller so that he receives on a regular basis the financial statements of the company, that he can follow up on it. And from the seller's perspective, you would want as well that in certain cases that negatively impact the earnout, such as a change of control or future sale of the company, that the entire amount of the earnout, the maximum amount, is due. So that's an acceleration clause. Last thing to be mentioned in that respect is that the seller will often require the buyer to provide a type of security for its obligations, payment obligations under the earnout, because the period can be 1 year, 2 years, 3 years, or maybe more. And of course, there's a solvability issue. So that's definitely something to keep in mind when you're on seller side. When you're on buyer side, on the other hand, the limitations that we just discussed to the possibility for the seller, for the buyer to run the business, is something to take into account, because you will not be able to do your post-merger integration as you want to do if the contract provides that you cannot, for example, merge the companies and things like that. So that's definitely to keep in mind. And with the outbreak of the pandemic, we do expect that earnout clauses will be more frequently used, especially for underperforming companies. We do expect that the time period over which the earnout will be calculated would be longer than usual, also because there's an uncertainty about how long this crisis is going to be. And yes, as a seller, of course, you want to have enough time for the business to pick up and to recover from the pandemic. So that's what we expect in the future. Let's move on to material adverse change clauses, a bit of a hot topic on the market right now and in the press. So a reminder, the MAC clause aims at giving the buyer the possibility to terminate or renegotiate the terms of the contract if circumstances change between signing and closing. And here we're aiming at negative, significant changes of circumstances. So the idea is that a contract has been negotiated with certain terms, the situation has changed, and the buyer may want to adjust. So we often, of course, hear the question, can the MAC clause be invoked based on the pandemic? The answer is it depends, as often. Lawyers reply always that answer. So the more specific the clause is, the higher the chances of success. You may want to have company-specific events that are specifically targeted and even when possible quantified. So you could say, for example, that a loss of key customers for an amount having an impact of so many euros on the business will constitute a MAC. Of course, in the current context, now that everybody is aware of the pandemic, parties will want to exclude the pandemics or include it. That depends on negotiations. And we see in recent cases, you probably heard it also in the press, in the Victoria's Secret acquisition, where the buyer, following the outbreak of the pandemic, tried to renegotiate the terms of the contract, was unsuccessful to do so. So they tried to walk away, trying to invoke the MAC clause, but unfortunately it did specifically exclude pandemics. So they could not rely on that. They had to try to rely on something else. And in the end, the parties settled the case. So we will never know what the court in Delaware would have decided on this. But that's in practice what we often see is that a MAC clause, the buyer will not necessarily be successful in invoking the MAC clause and terminating the contract, but it often gives you leverage to renegotiate the terms or settle. So that's what happened here, and that's what often happens in practice. All right, then moving on to our last topic, W&I insurance. I don't know if you are familiar with this concept, so I'll take a step back and give a bit of context. The seller's liability under an acquisition agreement can be quite significant in terms of amounts and in terms of duration. The buyer will expect that the seller takes full responsibility for the past, with certain limitations, of course. And the buyer will also expect to be able to claim such liability for a certain period of time. We often see 1 to 2 years, but it can be even longer for certain matters such as tax, where we usually provide the statute of limitations. So you have potentially this big liability, and the practice has developed a product called warranty and indemnity insurance, whereby the buyer, usually it can be the seller, but in practice it's 95% of the time the buyer who takes the insurance in order to ensure the liability of the seller under the acquisition agreement. So in practice, what does that mean? In practice, when the buyer has a claim against the seller, he will not go to the seller, he will go to the insurance instead to obtain reparation for his damage. And there's no recourse of the insurer against the seller except in cases of fraud. So clearly the main advantage is that there's a clean exit for the seller, his liability is drastically reduced, and it also implies that he will not have to provide an escrow agreement, an escrow account, or a bank guarantee, so it's cheaper for the seller. For the purchaser, there's a side advantage as well, which is that instead of dealing with the seller, who's maybe a business partner, you may not want to sue him because maybe the seller still is active in the management of the business, you act against the insurer. So it's a completely other party. It makes the claims procedure easier, and there's no solvency issue as well, or at least way less than with any party. And the advantage then for both parties is that the discussions, at least on the acquisition agreement, are reduced, especially on the liability clause, the liability cap, and the claims procedure. So this all looks a little bit too good to be true, and of course comes with a cost. It doesn't come for free. The cost is usually about 1 to 2% of the transaction value. It's borne by the buyer, but you can imagine that it has a repercussion on the purchase price. And as any insurance, bear in mind that it only insures unknown risks. So that means that the known risks, the one that have been identified in the due diligence of the buyer, will in principle not be covered. You could cover certain matters that are also principally excluded, such as environmental matters and GDPR, which both have quite a potential big exposure. You could, in your negotiations with the insurer, try to have these insured through a separate policy. So that will, of course, depend on negotiations with the insurer. And To keep in mind as well, if you want to call upon such an insurance, you should try to involve as much as possible the insurer in the process early on, because it can have a little impact on your timing. In practice, the insurer will review the whole due diligence reports. They will review the acquisition agreement. They will want to discuss with the due diligence teams to make sure that a proper due diligence has been carried out, because that's their risk, of course. So it can have an impact of a few weeks on the timing. It's better to involve them as early as possible. So in conclusion, it's a product that is not yet widely used in Belgium, at least. It's maybe different in other countries. And we often see that it's used mainly for larger transactions, probably also because of the premium that has to be paid. All right, then I think because we're running a little bit out of time, maybe we can address the questions by email later. And I would suggest that we move on to the poll. And I'm interested to know if you expect that earn-out clauses will be used more often during the COVID pandemic or not. Thank you.
So thank you to all my colleagues. I hope you had a nice lunch listening to us. I don't know, Geneviève, if you want to add anything.
I just want to thank everyone for having attended, and I hope that you learned certain things today. Quickly, we have other events, some of which were canceled due to COVID and or moved later in the year. So for the rest of the year, we have a Brexit event. That's a hot topic. It will be early November. We'll have another event on how to attract legal talent, another one on trade secrets, whistleblowers. Another one in December, how to run a workplace investigation. Everything is on our website, and you can go on acc.com, and you can see also under Chapter Europe, and you will see our events there. Thank you, Lydian. That was a lot of information. We learned a lot. I learned a lot myself, and thank you to all our attendees.
Thank you, Geneviève. And so I receive a few questions, and I will reply directly to the person, but surely co-ownership in terms of IP rights, it's really need to be avoided. I can tell you that already. And then for those who are also involved in B2C, we have also a seminar together with Lexology on the 22nd of October regarding the new EU reform on consumer protection and platform and seller. So have a nice afternoon, and we keep in touch, and enjoy the rest of the day. Bye-bye.
Bye. Thank you.